Hello students. So in this video, we're going to discuss about another very key aspect or area from where the passages in legal reasoning are asked, that are judgments, right? We have seen over past few years that CLAT consortium is asking in legal reasoning portion passages which addresses certain legal judgments from that particular year, or maybe it can be older judgment also, right? Now let's understand what does the word judgment means. Now, a lot of students think that judgment is the judge saying that this is correct, this is wrong. No, judgment contain multiple things and you have to understand what part of the judgment is being used to ask a particular question. So let's understand what is a judgment, right? Now, what are the parts of the judgment? First, the judgment contains 4 parts. First is factual metrics, second is issues, third is ratio, and fourth is verdict and relief, right? What is factual metrics? No, the judgment, whenever the judge is writing his judgment after trial, the first thing he writes is the factual metrics. That means the parties came, what happened, the factual things, right? For example, in divorce matter, the judge would write that on this date, the husband committed assault or battery on wife, because of which she left the home, right, of the husband. Then she approached the police station, she registered an FIR, after which the police conducted investigation. During investigation, these things came up. All these are factual things, right? All these factual things are first noticed by the judge, he writes it down. Then the second part is issues. Then issues are framed. Issues are questions, right? Based on the facts, the judge makes certain question. For example, whether according to the facts, what the husband has done is correct. Whether what the husband has done, is that an offense under this particular section? Is this section applicable on husband? All these are issues, the question mark, right? Things which ends with question mark. The questions are the issues, right? Once the questions are framed, the judge sits to answer those questions, right? Now, when he answers those questions, he gives his reasoning, ratio, right? To every question which is written in the issue, whether this is applicable on husband, the judge is going to first say yes or no, followed by a ratio. The judge would say that I have noticed the provision and I believe that according to the language of this particular code or section, I believe that this is my interpretation and therefore this should be applicable. Yes, it is applicable for the reasons I mentioned. Yes, this is not applicable for the reasons I mentioned. So all the reasoning are called ratio, right? And the last one is verdict and relief. Here the court talks about, say, injunction or the relief that is saying. Yes, say, issues are the questions, ratio is the answer to the question along with the reasoning, whereas the verdict is what is the remedy that is being offered. For example, after considering that yes, this section is applicable on husband, the court would say, therefore, I order husband to pay wife this much of money as compensation, damage. That can be a verdict. So operating part is the verdict, right? Now, you have to carefully consider these 4 parts and try to notice from where this particular question is being asked. And you have to individually deal with these 4 portions. That is very important. Apart from that, you have to understand the application. This is something you know. All the Supreme Court judgments are applicable on all high courts and the lower courts as well as the Supreme Court itself, unless a larger bench overrules it, right? High Court is applicable on all the lower courts within that high court's jurisdiction. You know that high court's jurisdiction is minimum of 1 state. It can be more than 1 state also. For example, Bombay High Court has jurisdiction over Maharashtra as well as Goa and certain union territories. Similarly, Madras High Court, its jurisdiction is not only confined to Tamil Nadu, but it's confined to few of the other union territories as well. So all those things, accordingly, high court's judgment will be applicable on all lower courts. Trial court's judgment is important whenever it reaches in appeal to High Court or Supreme Court because it is considered. So that is trial court. Then you have to see what are the parties arguing in each court, right? In the passage, it will be given that in High Court, the government argued this, the opposition argued this. In Supreme Court, when the matter reached to the Supreme Court considered the arguments which were presented by the government in the High Court. Are you understanding this? At High Court, one said yes, one said no. The Supreme Court appreciated the no given in the High Court. So then you have to relate which party gave it. So party at trial court, High Court, Supreme Court together makes multiple arguments on 2 sides. The favoring side and the one which is disregarding it. So both have to be appreciated when you read these passages, and you have to understand and put a limitation, or you have to demarcate it with a very good understanding, because whenever you reach question, these demarcations will be very useful to answer the question, right? With that, I think we come to the end. I hope that this video was useful. I wish you all the best. Thank you so much.